Hello and welcome everybody. I am your host today, Sarah Snell Cook, for this webinar, Whose Data Is It Anyway? Henry Meier, who will be speaking and presenting today, he's been an attorney specializing in financial services for more than 30 years. Henry has a broad range of experience in banking, compliance, appellate representation, education policy, legislative affairs, and regulatory analysis. Prior to starting his own firm in 2022, where he serves as a fractional general counsel or contract review, lots of different services he provides at the law firm of Henry C. Meier, Esquire. He's also served as a senior vice president general counsel for the New York Credit Union Association for 17 years. He worked as assigned appellate counsel, the New York State Supreme Court Appellate Division, and counsel to the Minority Conference of the New York State Assembly. Henry's comfortable speaking to audiences of 2 to 502. So please reach out to Henry or me if you'd like to book him for your next event, lunch and learn, or board meeting in person or virtual. And with that, I will welcome Henry, and you have the floor.
Thank you very much, Sarah, and thanks to everyone taking the time to listen to this webinar today. You know, where this came from was this is the time of year that a lot of people do look ahead at what's going to be the big issues for the coming year. So, in speaking to groups in Pennsylvania and in Texas, I realized that this was going to be a big that it undercurrent of so many of the issues we're dealing with today has to do with data and the changing nature of data. So the purpose of this and as Tessal said, I'm positioned to deal with these issues because of my work at the association and in working out with individual credit unions. We really cover a wide range of responsibilities ranging from general legal advice and consultation to anything as typical as contract review or account reviews as well for credit unions all across the country. So with that background, the whose data is in any way is one of the key questions facing not only lawyers, but also boards and CEOs, and I'll tell you why. Next slide, please. Because understanding, protecting, and utilizing data is going to be one of the key challenges facing all credit unions. So, and that's the argument I'm trying to make today. This is not about, we're really good as an industry in terms of understanding that we have to protect people's data. What I want people to start thinking about is data as an asset that's fungible, that is in the hands of many different people. And as it becomes more flexible and as it becomes in wider use and touched by more and more people, it's really important that we begin to think of our information, our data, as part of a supply chain. And where the data is at a given time is going to vastly affect all responsibilities, not to mention who exactly is involved in that information and data supply chain. So with that background, the way I'm going to break this up generally, just so we understand this, first I'm going to talk about some pending regulations, which are going to have a key impact on this question and really frame the issue once and for all. Second thing I'm going to do is talk about key contract terms. And since so much of this is not in statute or in regulation yet, so much of it comes down to what exactly you've committed to in your contract in terms of how your data as an institution is going to be treated. Third thing I want to talk about is AI. I don't want to make it sound like I think this is a good or bad thing. I do think that the commoditization of data is inevitable. You guys have a lot of it, and there's a lot of good things you could do to help your credit union grow and help your members maximize the value of their own data. AI is going to be a way of doing that, I think, but we are all going to have to be cognizant of some of the legal complexities that come along with using data in that way. So against that backdrop, let's get started. Now, if you don't want to take my word for it in terms of why data is going to be important to you, as a business and as a financial institution in particular, I want you to listen to what this young man had to say a couple of years ago about what he envisions your role to be in the future.
Or something like that. Like the long term, what we're really trying to build is we think things are going to be a little bit more decoupled. There's not going to be one financial system, and there's not going to be one company that's going to do 10, 15, 20 different portfolios of products. You're going to have a specialized system that's just handling your wealth, handling your brokerage accounts, sending payments, sending money to your friends, rent. All these different things are going to be kind of bespoke applications on your phone. Maybe you're going to still have a one-to-one relationship with your bank. Maybe you're still going to have your deposits in that entity. But in many ways, it's going to be a little bit more behind the scenes than it is right now. And so we think as a company, the most powerful place to be is actually that infrastructure layer that's building that network and behind it.
Okay, so I want you to concentrate on what he just said. If plan is correct, then the primary responsibility of your financial institution is going to be to hold your members' money for the benefit of other companies. You're going to be the ones who cover most of the compliance costs. You have to be the primary entities that are concerned about cybersecurity and other problems like that. But it is going to be the fintechs that are able to swoop in, take their money, and offer the fund products, the ones that help your membership grow, such as loans and mortgage loans, car loans. Now, that is not a particularly good model for the long-term stability of any industry. And that really comes down to who's going to have control of the data, what's it going to be used for, and what protections you have in place, and business plans you have in place to respond to this new reality. Next slide, please. So let's look first, like I said, we're going to look at the regulatory framework that is developing. And right now, there isn't much of a regulatory framework with regard to data portability, data protection, and data in general. But the CFPB is out to change that. In October of last year, the CFPB proposed an open banking regulation, and it may be finalized sometime this October, as early as this October. The basic idea, the 30,000-foot view, is that it would create an industry standard for the storage and transportation of data, and mandate that institutions with APIs, which is most of you, have a technological framework in place to permit your members to authorize a third party to take the information related to their account, analyze it, use it for their own purposes, and then effectively give it back to you when they're done with it. Now, what this means is that this is exactly the type of plan that the Plaza of the world would approve of, because it means that the fintechs, other bigger banks, are going to be able to use your hard work and your money and investments in building up accounts, swoop in, utilize the information contained in that account to offer the type of products that used to be offered exclusively by you. Now, the CFPB says that's great, that's the free market. But there are several issues that I have with that, including, next slide, please. There's an increased risk and vulnerability of exposure to cyber attacks. Let's face it, the bad guys are very good at pretending to be people they're not and tricking members into opening up accounts and stealing their money. Can you imagine how much more serious a problem that's going to be when you have a regulatory framework that authorizes third parties to take money from a member's account? There's going to be issues about who's responsible for identifying when a third party is in fact not authorized to take money. What responsibilities are going to be on the uh, on the app that is encouraging use of the third party information. How is the liability risk going to be split? So the liability issues involved with this are going to be large and ongoing. Okay. For your own purposes, this is something you're going to hear from. If you could go back one slide, for for your own purposes, one thing I'm going to be talking about a lot is um, understanding your due diligence responsibilities by identifying those aspects, those parts of the cybersecurity of the data supply chain that your data is most vulnerable, and what parties are participating in that chain. That's where you get into issues like fourth party risk, where you're identifying not only your vendors, but your vendor's vendor. Ultimately, like I said, we need to know where your members' data is on the supply chain. Next slide, please. So that's one question we have. What are some of the other questions? In terms of what your credit union is going to have to prepare for, you should be able to answer these questions or more accurately. If you haven't started asking them, you should start now. Do you know where your data resides within your financial institution and how it can be retrieved? Okay. By the way, if your information, your data is kept by a third party, let's say, but with your core processor or in the cloud, the fact that it's with a third party doesn't excuse you, of course, from ultimately being able to obtain and track that data. Okay. Who's going to be responsible in your credit union for ensuring that it complies with the standards called for under the new regulations? One thing I didn't mention about the CFPB regulations is it's all predicated on the creation of a national standard to be approved by the CFPB for ensuring that data can be transferred between financial institutions and can be available to the members in a machine readable form and a form that they can understand. So who is going to be responsible for ensuring that your credit union can ultimately meet those standards? Do you, and again, this is not all negative. This is an opportunity. Now's the time to start asking yourself, how do your members need use data? And is there something we can do to attract them to stay within our institutions so that they don't have to go to these third parties to get all these loans that or products that the fintechs offer? And as a sign of how serious the CFPB is, as part of that standard setting framework that the CFPB hopes to put in place, is already accepting applications from associations that would be that entity, that standard setting body. That tells me that now's the time for the credit union to be involved in the process. Your IT person should be looking at these issues now. Now, you do have some time, but not much. Assuming I have no one on this call of approximately 50 billion or more, you have institutions of between 850 million and 50 billion will have in total 2.5 years to comply with this regulation. So you have some time, but when you look at what's involved, it's going to take a lot. It's going to take a lot of time to get ready. If you are under 850 million, you have some additional time, approximately 3.5 to 4 years. Again, though, it's going to take some time. Now, you do have the option of not offering an API, but once you understand that an API is basically software that allows people to access their accounts from outside your credit union, many of you already have that type of technology and we're already doing a contract now involving online banking, in which the API is a major part of that. And the reality is that for those of you who don't, it's going to be extremely difficult to be competitive if your credit union doesn't offer this type of technology. Next slide, please. Now, I'm talking a lot about what data is, but the reality is, like I was saying at the beginning, there is no set definition that is uniformly accepted of what data is. So that that issue is ultimately dictated by the evolving regulations and legislation in this area, as well as in contract. But first, I want to talk about some of the regulatory definitions that the CFPB is proposing. Next slide, please. Now, the CFPB basically defines data for purposes of its proposed regulation as data which any information which you would get as a result of utilizing a transaction account. That means that, or that you would get pursuant to exercising your rights under Regulation 8. Okay, it relates to things such as the number of state transactions, when they were made. It also refers to basic information such as the email or phone number of verification, some way of verifying that account. Now, ultimately, this is an important definition because one, it's quite expansive. Two, it does mean that you would have to provide bank statements, effectively electronic bank statements, going back as long as 24 months without being compensated. That's a big deal. If for nothing else, there's an expense involved with that you won't be able to recover. So the CFPB takes a very broad approach to its definition of data, encompassing basically information that you would expect to be generated from your typical account. One other thing I want to point out about their definition, it would also include the terms and conditions that are needed to get the terms being offered by a given product or account. For instance, many of you now offer account benefits where if your member maintains a certain level or agrees to have direct funds directly deposited into the account, you will increase their interest rates. That type of information would have to be provided to the member and to the member's third party, authorized third party, when asked for. Next slide, please. Now, there is some good news, okay? First of all, and most importantly, there's two things I want to highlight about this slide. It does not extend to confidential commercial information. So as some of you get into the use of proprietary algorithms, that, for instance, a unique algorithm for providing for this underwriting mortgage loans, you would not have to provide that algorithm, okay, or explain how you got the credit score you did, okay, and not surprisingly, I used to be SA an example. If the data is data that has to be kept quiet, confidential, pursuant to federal law, then you would keep it confidential. That means that don't think that as a result of this requirement, a third party, for instance, is going to be able to find out whether or not a SAR has been filed in relation to one of your members' accounts. Okay. And finally, remember too that when we're talking about the definition of data from a regulatory standpoint, we of course have a lot of state level activity on this issue as well. So if you are in a state such as Virginia or Colorado that has data privacy and portability standards, you got to look to those definitions as well. And you're going to find though that first, in many cases, financial institutions are exempt under the statutes. But two, the basic framework that the CFPB is putting in place and the type of steps I believe we should all be preparing for in response to these type of initiatives are pretty much uniform. Next slide, please. So another issue as to what is it is not data are the contracts that we sign with vendors. Most notably, but not exclusively, the information we put in our core process of contracts and agree to under the core process of contracts. That's the key one, but there are other vendor agreements in which we deal with data and what can be done with it every time we sign the contract. So the contract is a key source of information. And if you want to understand what's being done with your data, you have to understand what you're agreeing to under your contracts. Next slide, please. And as I said, there is no uniform definition of data, and it can vary in subtle but important ways. For instance, these are three sample clauses I came up with. I pulled they're all legitimate. But they all have slightly different variations. So the one on the bottom, for instance, refers specifically to information related to the core processor and anything we put into the core processor. Um, the same thing with the one on top. Now, the one in the middle takes a much more expansive view of what constitutes member data. It's absolutely crucial, though, to understand these distinctions, because if you're going to know where your data is and who can have access to it, you have to understand what, in fact, constitutes data under your contractual arrangements. Next slide, please. So, against that backdrop, here are the key data-related questions. So some of the key data-related questions you should be asking when you're considering entering into a contract involving data, most notably the core processor or online banking services, those type of issues. Okay, like I said, how is data defined? And then how can the vendor use the data? Typically, the standard is you cannot use data for any reason other than the intended purpose to execute the terms of the contract. That being said, you are seeing more and more language about what's called de-identified data, and it's used in the context of what's called analytics. De-identified data is a fancy way of saying data which has been so jumbled up that it can no longer be associated with a specific member. That is the technological assumption. Why is this valuable? Because the way AI systems work, and particularly AI models, whole language AI models, it is extremely valuable to get as much data as possible into the analytical framework and model you're creating. It helps validate the model. As a result, even the identified data has a value. And even in that context, if I'm a processor, if I'm a company that deals with online banking, I probably want the right to use that data. And you should at the very least understand what's being done with it, and understand the assumption that this is in fact fully information that can't be tracked back to your member. Okay. A very interesting issue that's developing. You're seeing more and more contracts refer to intellectual property rights. Why is that? Because it's one thing to say the data belongs to you, but what does that actually mean? Does it mean that the report created pursuant to your data is yours? Okay. Does it mean that that if the credit union comes up, if the core processor or the vendor comes up with an idea as a result of a conversation with you about what you're looking for in your data production, that is their idea or your idea in terms of who's going to have the right to profit from it? These are all issues that are coming up. They're new issues, and that's why you're seeing them addressed in the contract itself. Okay, and then some more practical ones. Okay. One of the big issues with core processors is that it's extremely difficult to get out of the contract before the term is up. And even in the event that the term is up, they're not exactly nimble when it comes to assisting you in making a transition. So do you have any information, any provisions in your contract dealing with baseline expectations for helping to transition to a new data provider or a new servicer in the event that you think, let's say you want to move to a new core processor? Can they simply say, no, we don't have to give you the information? Or, okay, we agree to be reasonable in terms of having machine readable data that we will help you transmit to your new vendor. Okay. Another key issue to keep in mind is, what obligations does your third party have, with regard to his vendors? In other words, you might have the best agreement in the world and the best conditions placed in place with regard to what obligations the party with whom you're contracting with, the core processor, I'm going to use the online banking or uh, the cloud provider you might have. Okay, you might have the best language in the world, but if that language doesn't extend to the subcontractor being used by that vendor, it's not going to be of much value if it's the vendor that ends up being, if it's the third party vendor that ends up being vulnerable, and the vendor's vendor that ends up being vulnerable to things like cyber breaches. Next paragraph. Oh, and one other point I did want to point out as well, and this is becoming an issue, or should be addressed. Many of you are now transferring from a license-based system where you have a tangible piece of software or hardware even online, on your premises, to a subscription-based course system in particular, where you are simply logging in and transporting your data to a third-party platform. Now, whereas in the old days, where you had physical possession of a software license and the ability to use that software, if XYZ company went out of business, you would still have the ability to use and operate that software. We really don't know what's going to happen or what would be the implications in the event that a subscription-based let's say a subscription-based core provider was to go bankrupt. Who has control of that information? Do you have the right to get your data back? And will that third-party provider, even though it's bankrupt, still have some means of making sure that you can continue your code processing services, or will you have to quickly find another vendor? Have fun with that one. These are all issues that I'm going to show you. They're not abstractions. We're already seeing cases where these type of issues have arisen. Next slide, please. And of course, while today's conversation is concentrated on the issues of data portability and the type of issues that you're going to have to deal with in terms of the big global picture, we all still have those baseline privacy protections. So, are your vendors complying with your obligations under Part 748? And do you have the proper notification procedures in place so that in the event your third-party vendor, let's say it's your cloud provider or your core provider, gets victimized by a data breach, that you will get notified, and then you can comply with your obligations to notify NCUA and in some cases your membership. Next slide, please. Now, I don't want you to think that all this was an abstraction. It wasn't. These are issues that are coming up now and that need to be addressed, and that are being addressed in default. Okay. For instance, I think the latest example, unfortunately, the best example so far, has to do with the Trellance ransomware attack. Last November and December, as you may recall, approximately 60 credit unions were subject to could not get access to their members' data. In other words, members had varying degrees of lack of access to their own data because the data being held by Trellance was being victimized by a data breach. Now, the problem is many of these credit unions didn't directly contract with Trellance. What they did was contract with FedCom, which acted as an agent of Trellance in some respects, but not in others. And as a result, it was extremely difficult for the credit unions to know exactly what was going on, exactly who needed to be contacted. It was so difficult that even NCUA was complaining that it lacked the information it needed to assess what could have been a very serious issue from a safety and soundness standpoint. So, what are the key issues, takeaways from this? When someone is acting as an agent on behalf of another party, be very skeptical of language which picks and chooses precisely what activities that the party who the acting as agent is acting for is going to be responsible. So in other words, XYZ company is an agent for ABC company, but only to the extent that it offers these following services and not the others. there's a reason why that exception is in place, and it probably is going to be now their scope of responsibility. And if one of those things to try to take out is something that you need to have parties be held accountable for, then you should really pay attention to that. That is one of the key ones. And then there's a real practical one, which is even if you don't think you're going to have the leverage to deal with this in the contract, you need to know again, this is a theme throughout this entire discussion, what parties are involved in that data chain, data production chain, and who makes us vulnerable to attack by virtue of the fact that they could be vulnerable to attack. For instance, I'm sure many of you, or many of you, some of you did not even know that Trellix was the cloud provider, or the provider that gave you cloud access. But it was a crucial issue once this ransomware attack occurred. Next slide, please. Then there's another issue to show this is not an abstraction. In another case, this has not gotten the attention it should be getting, frankly. Many of the fintechs you see advertising great services. They sound like a bank. They act like a bank. They strongly imply that the products they provide to members are FDIC insured. In fact, many of those fintechs are non-depository institutions. And what they do is they take members' money, and in the best case scenario, they do put that money into specific banks. But they are not financial institutions, so they often will get another vendor, in other words, a vendor's vendor, with the specific responsibility to aggregate those funds that they acquire from consumers and make sure they are placed in the appropriate banks with whom they have a contract. Now, this is basically what Synapse did. And Synapse went bankrupt. And as a result, all of a sudden, many, many people did not have access to their account because there was an issue as to, well, whose assets are these? Do they belong to the bankruptcy estate? Or do they belong to the specific member? Then we found out that some of the bookkeeping wasn't as solid as it should have been, as we would have hoped. My point with all this is that, again, what would happen in our situation if those subscription-based core services that we are getting online, what would happen if they went bankrupt? Do you have a provision in place to guard against that eventuality, or do you simply make sure that you have the ability to monitor the financial health of those companies and are taking the appropriate steps and can mitigate those concerns by quickly getting out of the contract? Now, one thing I have done for a credit union in the past is set up an escrow agreement whereby the fintech or the core will agree to put the language needed, the computer language needed to operate that core system will be placed in escrow, and credit union can have access to it in the event of a bankruptcy. Now, while this may be an attractive sounding alternative, and I have done this in the past, the question is going to be, do you have the ability as a credit union to ensure that a party can utilize that software and knows how to get the systems up and running again? If it doesn't, then this really doesn't help you. And like I said, you're all going to be vulnerable. It's one of the reasons why you really should make sure you are cognizant of the financial health of institutions before you get involved with them, particularly startup fintechs with great products, but you don't know what's going to happen to them in 5 years from now. Interestingly enough, we have credit union land, and there's always an assumption that credit unions, CUSOs, they will make us whole one way or the other. But hope and a prayer is not a way to run a business, particularly when the product we are dealing with is your entire identity. Without a core processing system, without access to members' money in a quick and efficient way, you don't have a financial institution. Next slide, please. Many of these issues were addressed in one form of the or another in a case called Bessemer versus versus Pfizer. Okay, I like this case for several reasons. First is that fight Bessemer is a small 4,000 member credit union that was able to take on Pfizer and ultimately was able to survive a motion to dismiss, which allowed it to bring several claims against Pfizer, which have proven would have entitled to damages beyond the contractual liability cap. So this was a big win for credit unions. They also had to bring a separate action called a bailment proceeding because there was such a big dispute as to who had control of the data of the member data and who was ultimately responsible and entitled to that data. So again, these are not abstract issues. They are being debated, they are being litigated, and the more we start addressing these in the contract and we're appropriate in regulation and hopefully federal regulation, and laws, the better off we will be. Okay. How are we going to do that as well? Well, one way we're going to do that is by getting, I would suggest that within 5 years, we're all going to have chief data officers. Okay. Just like eventually you all ended up with BSA officers. This is going to be such a big issue that eventually there is going to be someone in your credit union assigned for knowing exactly where your data is and who has it at any time. Next slide, please, Sarah. Okay, so if the bankruptcy doesn't help and you don't realistically have much leverage against some of these major providers, what can you do? Well, it all comes down to ultimately the best protection you have is the pre-contract due diligence. And for that, even though we're dealing with a new area, it's the same tried and true guidance that has been out there in the past. Evaluating third-party relationships is still a standard document that you should all be looking at. It encapsulates nicely what NCUA is expecting. And I can tell you that NCUA is going to have a greater emphasis on appropriate due diligence after the trillions problems that everyone experienced over the last year. Another great source of information, if you really want to get up to speed with this stuff and make sure that you're doing things above and beyond in some cases, is the FFIEC recently did a update to its booklet on development and maintenance of and acquisition of software and technology. Extremely interesting issue because it does go extremely interesting publication to the extent that this is your responsibility, because it does take a whole life cycle approach to what your responsibilities are and addresses issues such as safety and maintenance of the data on an ongoing basis. Next slide, please. I don't want to create the impression that data is a bad thing. I don't want to create the impression that that is a necessary something that you only need to do is protect it and don't worry about using it. There's a great, for those of you who like the old Westerns, there's that great line in Shane where Alan Ladd goes, a gun is as good or as bad as the man who uses it. And I feel the same way with data. There's, with the explosion of big data, there's an amazing number of things that can be done with your members' information that can make it more beneficial for the credit union and for that membership. For instance, I was with a salesman recently who showed me that he was able to pinpoint precisely when someone was most likely to be getting ready to do a home remodeling product. Isn't it nice to have that information if, for instance, you want to offer a home equity loan to those people? Next slide, please. But what is artificial intelligence? And again, there's no standard definition at this point. I live like this one, which I pulled from a law review on. And the key is that, to me, what makes artificial intelligence so significant is that it is trained on a model, and then on its own it can make predictions, okay? And it also learns and reiterates from those models. So in other words, we create the framework, the software framework, but then it's going to have the ability to extrapolate its own conclusions, to modify um, lending algorithms in our context. And it's that ability to create things which we may not directly understand or directly control that makes AI so potentially useful and frightening to some people, particularly in the lending context. Next slide, please. Now, occasionally I do write for the CU Times, and I wrote an article titled, Can AI and fair lending coexist? Well, I got a lot of pushback from that article because of the title and because of some of the concerns I expressed. And I ended up talking to people from Zest, which is an AI provider, a provider of AI-driven lending solutions. This is not a plug for Zest, but in talking to them, they said, Henry, there are several good things that can be done with AI, such as helping the underserved communities by giving underwriting standards based on the unique criteria that we might not have been able to consider before. But the key is going to be doing this in a way that is consistent with the regulation. And here's the key distinction that they explained to me, and that we should all know as we go into the issue of AI. Next slide, please. There are two types of approaches you can take to AI. There is an open source model in which you basically suck all the information out of the internet, and we all know how accurate the internet is, and use all that information to create and refine a model which has predictive ability, or arguably has predictive ability. For instance, I'm experimenting with contract software that makes it much more efficient and quicker for me to spot potential weaknesses and strengths in contracts. The interesting thing about that software is it is sucking things out of the internet. Okay. Now, that means that, like I said, I ultimately have to have the wherewithal to know what is credible and what is not, because not every source they get is going to be a good source of information. Now, it's one thing to do that in a contract, which is fairly straightforward. It is another thing to use that approach in the context of lending, where we don't know where that information is coming from. And we engage in what's called black box lending, where we don't know where the information is coming from, and we can't explain how it came up with the decisions it did. So with that context, in the way about a year and a half ago now, when the whole issue of AI taking over the world was first being proposed, the Justice Department, the CFPB, FTC, and the EEOC, and maybe the Department of Labor came out with a joint guidance. And for your purposes, the key to this joint guidance is that we are not going to let the use of AI excuse you from complying with basic fair lending rules and requirement. In other words, we still expect you, for instance, I'm going to use this as an example, to be able to articulate, pursuant to the Equal Credit Opportunity Act, why a member was denied a loan. We still want you to do that at the end of the day. Well, my issue and what got me interested in this topic was, okay, how can a lender basically do that? If by definition, the computer is generating its own decision based on criteria that we may not even know or fully explain where it came from. And that is exactly what the Justice Department is concerned about. Beware of people who use black box lending. Okay, in contrast, the argument goes that the other approach is to use what I'm going to call a closed box system, in which everyone knows what data is being put in to the model, what information is being used to generate the model. And ultimately, I am told that people who use this more closed box approach do have the ability to explain, or hope to have the ability to explain in compliant ways why the lending decision was made. That's really the key. At the end of the day, if people start getting denied loans because of AI that AI, and it can be shown that under traditional underwriting standards, they would have gotten along. We better all be in a position where we can explain that. Okay. Now, next slide, please. Who's right? Is AI something which can be done in a way compliant with fair lending law, or is it something that if we're going to let go, we have to let go organically and provide more flexibility ultimately to our fair lending laws? Well, I'm not a technical person, so I won't make that guess. But on a purely practical level, here's where the rubber meets the road. If someone is trying to sell you AI-based technology, and they're saying that we can quickly produce and more efficiently give you um, underwriting criteria, which helps your membership and which quickly provides loan decisions, then you're going to say, okay, are you going to want that or guarantee that information, that decision is compliant with the fair lending laws in general and the Equal Credit Opportunity Act in particular? If they say no, then understand that you better understand the criteria being used and why it's being used, because you are going to be responsible for knowing why the data, why this result was reached, and ultimately, um, how come it is data, and what about this data uh, do we know about to ensure that it is not data which can be used to discriminate as opposed to help us reach a fair and objective underwriting decision. That's going to be one of the key issues. And like I said, that's one of the key issues that should be discussed as you begin to be approached by vendors who say they have this great and efficient AI technology, because I do think a lot of it is great and efficient, but it is also very risky from a fair lending standpoint. It's a brave new world. Next slide, please. Okay, with that, I am done. If you would like to follow up on anything I've discussed, see what type of framework you might want to consider, or some of the other issues, or see if there are contracts or new systems that your credit union might want to consider putting in place, please feel free to give me a call. Or if you just want to talk more about these issues again, please give me a call. Thank you very much for taking the time, and I hope you enjoy learning about this fascinating issue, which is going to impact all of us for about the next 10 to 20 years until the next big thing comes along. Thank you.